Welcome to today's webinar, where we will be reviewing the highlights and developments in IP litigation in the year 2025. My name is Daniel Davies. I'm a principal at Smart & Biggar in the litigation group. And with me is Matthew Burt, also of the Smart & Biggar litigation group. Of course, our firm, Smart & Biggar, has top specialists in all areas of IP law, and we do have some webinars on other IP-related topics, but this one is focused on litigation and enforcement. Before we dive into the content, a few housekeeping details. First, our presentation will be about 50 minutes and will be followed by an open and interactive Q&A session. You are welcome to submit questions at any time during the presentation by clicking on the Q&A panel at the bottom of your screen. We will try to address as many questions as we can in our live session. If you require live captions in French, please turn on Show Captions in the Zoom toolbar, select Translation, and choose French Canada as your caption language. This webinar is being recorded. You will receive an email with a link to the recording, along with a PDF copy of the slides following the session. And at the end of this webinar, a survey link will pop up. We would appreciate if you could take a moment to share your feedback on today's session and let us know what other topics you are interested in learning in the future. With that out of the way, let's jump into the content. And the first topic we're going to discuss is a case that came out in 2025 in which something fairly rare happened, and that's that some copyright pirates were actually sent to prison as a result of being in contempt of court. You see the case citation up on your screen. It's the Bell Media and Machiachera case. And what this case relates to is sentencing for contempt of court that was committed by the operators of an IPTV service. For those who aren't familiar with these, an IPTV service is essentially a service that pirates TV broadcasts and provides their users with unauthorized access. So people sign up to these services, they get really cheap TV, but it's all illegal. And so Bell Media finds out about the service, they go to court, they get an Anton Pillar order, which is sometimes called a civil search and seizure order. It's an order that allows for the search of the infringer's premises in order to seize and preserve evidence relating to their activities. And this order also required the defendants to disclose certain information as part of the Anton Pillar order. But unfortunately, an issue that sometimes comes up is, well, what happens if the defendant just doesn't listen to the court order? And that's where you end up in contempt of court proceedings. So these are no longer about infringement per se, it's about not following a court order, and it's actually more of a quasi-criminal type of proceeding. You're found guilty of contempt, and if so, you get sentenced. And that's what happened here. The plaintiff brought contempt proceedings because the defendants were refusing to follow certain provisions of the court's order, and the defendants were found guilty of contempt. And then the issue became, well, what should be the penalty? And if we go to the next slide, you can see if someone is found guilty of contempt, there are various penalties that can be imposed. You can have a fine. You can get an award of costs on a heightened or solicitor-client basis often. You can have further orders being made by the court that are designed to force compliance. And at the more extreme end of the penalty spectrum, you can have incarceration as one of the possible sentences. Now, some might have argued in the past that, or maybe still do, that some of the fines imposed have seemed a bit lenient. Often the costs can be quite high, but the fines can be lenient, and it's been fairly rare to see actual prison time, or at least substantial prison sentences, are quite exceptional. But if we go to the next slide here, the court thought that something pretty substantial was required and actually ordered prison sentences of 6 months and 4 months for these defendants for contempt that they had perpetrated already. And if they were not going to cure their contempt by actually following the provisions of the order that they had been refusing to, then they were going to be imprisoned for 5 years. Or if they did follow it, then they would get out, but 5 years if they continued not to follow the court's orders. And so the question is, why did the court do this? And on that, there's a few pretty interesting points that the court made. One is that the court has started catching on that these IPTV pirates were treating not only infringement penalties, but contempt penalties as kind of a cost of doing business. And all things considered, it seemed like they were still viewing contempt as worth it in the circumstances. They were actually following developments in the Anton Pillar context of what was happening in the law, what kind of penalties were being imposed, and thinking, well, still think it's worth it to not follow the court order. And the other thing that the court, or another thing that the court comments on, is really, when you're talking about Anton Pillar orders, if we go to the next slide, their purpose is to preserve evidence that the court is convinced is likely to be hidden or destroyed by an unscrupulous infringer. That's why you got the order in the first place. And the effectiveness of that type of order depends on a certain element of surprise. You show up at the defendant's premises, they haven't been notified beforehand. You have the independent supervising solicitor explain them the order. Usually there's a police escort. But what happens if, instead of following the order and allowing the evidence to be collected, you have the infringer just closing his door and going back inside for a few hours without letting them execute the order or even see what you're doing in that time? Well, then there's a good chance that some of the evidence, maybe some of the most important evidence, is just not going to be there anymore after those few hours is up. And something that's important to keep in mind, an Anton Pillar order is not a criminal type search warrant, where if the police show up with a search warrant at your house in a criminal context, that they're searching your house whether you like it or not. An Anton Pillar order is one where the court orders the defendant to allow the search, and they can say no, which is contempt of court, but you can't actually do the search until they say yes. So the whole system depends on people taking court orders seriously. And if the pirates are thinking, oh, well, it's just the federal court, I can defy their order and I'll probably only get a slap on the wrist, then the system does not work. And so the court is really looking to dispel the notion that it's lenient and even more lenient than potentially the provincial superior courts. And finally, remember that part of this is continuing contempt. So despite being subject to contempt proceedings and being found guilty, the defendants still weren't going to follow parts of the court order, which they openly admitted during the hearing. So it's like if the police pull you over for speeding and you're like, no, officer, I'm not going to slow down. Just give me my ticket and let me go on my way. Well, they're probably not going to be too lenient on you. And that's exactly what we see here with the court really not being comfortable with the idea that these defendants were just not going to follow their order regardless. And so the court ultimately decided, well, if that's going to be the case, you're going to be in prison for as long as I can possibly put you there, which was that 5-year sentence. All right. So seeing a few questions potentially having come in, I think we'll address them at the end. But for now, I think we can go on to the next topic, which is claim construction and essential elements. So this is changing gears to some patent law, and there's been a couple of interesting cases in 2025 dealing with patent claim construction. And when we're talking about claim construction, construction in this context means interpretation for maybe the non-patent people in the audience. Claim construction is claim interpretation, and the claims are the part of the patent that define the monopoly that the inventor gets for the invention. It's like a list of elements, and as long as the patent is in force, other people are not allowed to make or practice something that has all those elements in the claim. Ultimately, claim construction tells you, well, what does the patent claim actually cover? So if we go to the next slide, we have guidance from the Supreme Court of Canada. The way you're supposed to interpret claims is through this purposive analysis. It's kind of similar to the approach we use for statutory interpretation. And one part of that purposive construction that the Supreme Court has talked about is distinguishing essential from non-essential elements. So basically the claim says something, it has an element in there, but the skilled person in the field would know that you could substitute that element and it wouldn't really make a difference to how the invention works. And also they wouldn't read the claim as demanding strict compliance with that element. So maybe you have a claim that talks about two pieces being attached with a nail, but the skilled person would know, well, I mean, you could use a nail to attach those things, or maybe you could use a screw, and they would read the patent and not think the inventor meant, oh, it definitely has to be a nail. Maybe it could be something else that does that attaching of those pieces. Well, then you would have what's called a non-essential element. So even if the alleged infringing product didn't have a nail, but it had a screw, it would still be infringing because the only thing that it omitted was a non-essential element. So that's what the essential element analysis is all about. But a question that was not so clear in the case law is whether the court should presume that everything is essential, such that there's a presumption to overcome if one wants to establish that one of the elements is non-essential. And that brings us to the AGI short track case that appears on this next slide. And in this case, the plaintiff ended up claiming for the first time in their closing argument that two of the claim elements were not essential, so that even if the defendant's device didn't have those two elements, no big deal. They're non-essential. They don't need to be there. But that wasn't part of the expert evidence they had submitted, and they really only raised it for the first time after the trial was coming to a close, and they were putting in their last piece of argument. The trial judge ultimately found that those two elements were essential, but in doing so, he referred to the idea that elements are presumed essential. So without expert evidence, it was going to be hard for the plaintiff to overcome that presumption. And the trial judge found, no, everything's essential. They're presumed to be essential. You didn't prove otherwise. And that's that. But when we come to the Federal Court of Appeals decision, they say, well, that's not technically correct. There, in fact, is no presumption that every claim element is essential. You're not supposed to presume one way or another. My interpretation of this decision is that that presumption is not a rule of construction. So you read the claim, some elements might be essential, some might not be essential. You're not presuming one way or the other. But what the court also says is that as a matter of procedure, the party asserting that an element is non-essential does bear the burden of proving that point. So if you want to say something's not essential, the burden of proof is on you, but the court shouldn't be applying a presumption that everything is essential when they're doing the analysis. And not only do you have the burden, but if we go to the next slide, the court also indicates that you have to maintain the assertion that the claim element is non-essential. Raising it in closing argument for the first time, that's not going to be good enough. Probably, if it's not in your expert report, then you've lost the opportunity to assert that a claim element is non-essential. So the court ultimately concluded that the trial decision was still correct in finding that all the claim elements here were essential, but did clarify this point about the presumption. Another case that we saw on claim construction is this McCain and Simplot decision. And this I found is a good practical illustration of how claim construction works. In full disclosure, I acted for Simplot in this case, so this might not be unbiased, but in this case, one of the main issues was construction of the term high electric field, and specifically whether it encompassed a technology known as pulsed electric field, or PEF. And so the court goes through the whole purpose of construction analysis. One thing the court considers is, well, does the term high electric field have a specific meaning to the skilled person? The answer was no. The skilled person might come across the term high electric field, but they would think, okay, well, I better read on in whatever document this is to figure out what it's really talking about. It doesn't mean anything specific. Kind of like if you use the word fast out of context, well, it can mean different things if you're talking about like running or car racing or particle accelerators. So it didn't really have a a meaning from outside the patent that could be attributed to it. The court goes on to look at what the disclosure actually talks about. Disclosure talks about an example where potatoes are subjected to an electric field of 45 to 65 volts per centimeter for 3 to 5 seconds. Goes on to say that maybe this process could also be used for other fruits and vegetables, and you're looking at probably a range of 30 to 75 volts per centimeters for 1 to 10 seconds. And this is understood to be continuous alternating current electricity that's being used. But PEF really was a different type of electric field technology from what was talked about in the patent. It's 10 to 100 times stronger. So instead of talking about 50 volts per centimeter, maybe we're talking about 1,000. It can be a millionth of a second or a thousandth of a second, really, really short pulses. It needs special equipment in order to be able to do that. And it's always described in association with the word pulse in the common general knowledge. And not only that, but the effects are very different. Different effects in nature from the types of electric fields discussed in the patent. All that comes together, and the court concludes that the skilled person is just not going to read the claim in the context of this patent as referring to or encompassing PEF, which is a very different type of technology than what the patent actually talks about. And if we go to the next slide, another thing that is well reflected in this decision is that a super broad claim construction doesn't necessarily mean you're home free, because you start running into validity problems. And here, one of those problems was utility. For utility, you need to show that basically utility is whether the invention actually works, which is one of the requirements. You need to have demonstrated or soundly predicted that by the filing date. And the scope of the claim has to be commensurate with what was soundly predicted. And here, the court finds that, well, there's no sound prediction that would have encompassed PEF. It's different, not just in degree, but in kind to the types of electric fields discussed in the patent, or that, and outside of anything that could have been soundly predicted or demonstrated based on what was actually done and what was disclosed in the patent itself. McCain tried to get around that, essentially arguing something along the lines of, well, if we construe the claim to be any electric field that reduces resistance to cutting, then we could soundly predict that any electric field that works would work. And the court was having none of that, and ultimately concludes that you can't get around this utility requirement by construing the claim elements to be limited to only what ends up proving useful. So if the broader construction had been applicable, the court finds, well, nevertheless, the claim would be invalid for lack of utility. I'll now turn it over to Matt, who's going to discuss a couple more topics. Please go ahead, Matt.
Thanks, Dan. And so the next topic is a brief update on costs. And it seems like every year we get one or two noteworthy decisions on this issue. And in 2025, there was, in our view, a notable decision from the Court of Appeal, the Federal Court of Appeal, which provides some helpful guidance on how costs should be calculated in the appellate context. And just before I get into that decision, just briefly give some background on the cost regime in Canada. So in general, we have a loser pays system. So the successful party in an IP case is typically awarded a portion of their legal costs and also all of their reasonable disbursements, which includes, for example, expert fees. And in the federal court, there's one of two ways to calculate costs. One is under the tariff system, which essentially assigns a range of costs to certain steps in the proceeding. And the second is as a lump sum percentage of the actual legal fees that you incurred during the course of the action. So we reported on this in last year's litigation year in review webinar, but in recent years for IP cases, there's been a pretty clear and consistent trend of costs being awarded as a lump sum percentage, often in the range of 30 to 50%. And I think the primary reason for this is that the lump sum award provides a more reasonable contribution to the actual fees that were incurred by the successful party. And also it's more of a broad axe approach. So it's in theory easier to calculate. You don't have to go line by line and evaluate which steps were undertaken through the course of the action. Instead, you just take a percentage and apply it to the actual fees incurred. And so, as I said, on the screen, we've put a few recent examples. This is in the patent context of cost awards on the calculated on the basis of a lump sum percentage. And so what about costs in the appeal context? And that was the issue that was addressed in the AGI SureTrack case. This was the one that Dan was talking about previously. So this is the costs aspect of that appeal decision. So this was a patent infringement case. The patentee was unsuccessful at the trial level, and the successful party sought and was granted costs based on a lump sum percentage of their actual fees. The patentee then appealed that decision, and that appeal was ultimately dismissed. And once again, the successful party on the appeal sought costs as a lump sum percentage of the actual fees that they incurred in respect of the appeal. And so the Court of Appeals said at the outset that if a party is going to seek an elevated cost award based on a lump sum percentage of their actual fees, they have to prove or establish that such a cost award is warranted in the circumstances. Secondly, they also acknowledged that at the trial level in IP cases, they acknowledge that it is the practice or there is a trend of awarding costs based on a lump sum percentage. However, and what I think is interesting from this case is that they stated that cost awards in the context of IP trials are not benchmarks for cost awards in the appellate context. And they proceed to identify differences between the two situations, the trial proceedings versus appeal. So on appeal, you don't have any expert reports. You have much shorter timelines to get to the hearing. You have fewer motions, if any. And most importantly, appeals are constrained by the grounds of appeal, and all the issues are considered through the lens of the appropriate standard of review. So they're much more narrowly focused. And for those reasons, ultimately, the Court of Appeal awarded costs to the successful party just beyond the maximum permitted under the tariff. And so from my perspective, at least, there are a few takeaways from this case. I don't think anything the Court of Appeal said disrupts the practice and the trend that we've been seeing at the trial level in IP cases that costs are awarded as a lump sum percentage. However, and recognizing that cost decisions are highly fact specific, I think it's difficult to ignore the comments from the Court of Appeal, which seem to suggest that tariff-based costs might be more appropriate in the appeal context. Okay, so the next topic that I'm going to discuss is limitation periods for patent infringement actions. And in 2025, there was a decision from the Alberta Court of Appeal, which provides some clarity as to which limitation period applies to patent infringement actions brought in Alberta Provincial Court, whether it's the limitation period prescribed in the Patent Act, or is it the limitation period prescribed in the provincial legislation. And so again, just to give a bit of background before getting into the case. So in Canada, both provincial courts and the federal court have concurrent jurisdiction to hear patent infringement cases. So the patentee can decide to bring a patent infringement action in provincial court or in federal court. Now, as I alluded to, under the Patent Act, Section 55.01, this section has been interpreted as a limitation period, and it provides that no remedy may be awarded for an act of infringement committed more than 6 years before the commencement of the action for infringement. Okay, so it's in essence, or has been interpreted as a 6-year limitation period to claim remedies for an infringing act. Now, each province has their own legislation which addresses limitation periods for civil claims. And in Alberta, it is the Limitations Act, and it's Section 3, which in essence provides a 2-year limitation period. So if a plaintiff knows or ought to have known that they have a claim as of a certain date, they have 2 years to file and have that claim issued in the Alberta Provincial Court. And so the question that was before, the issue that was before the Alberta court in the case of JL Energy and Alliance Pipeline was which limitation period applies to a patent infringement action brought in Alberta Provincial Court. And for context, a few years prior to this decision, the Alberta Court of Appeal decided that it was actually the 2-year provincial limitation period that should apply. And so at the lower court level, at the Alberta King's Bench Court level, on this motion for summary judgment to dismiss the claim for being outside of the 2-year provincial limitation period, the Alberta King's Bench Court followed that prior precedent and dismissed the claim as based on the facts, as you could see on the screen, it was outside of that 2-year limitation period provided by the provincial legislation. So that decision was appealed to the Alberta Court of Appeal, and this time they reversed the decision, and they also noted that their prior decision indicating that the 2-year limitation period should apply, should no longer be followed. And their reasons are fairly thorough. They go through an analysis of the language of the Patent Act, of the Limitations Act. They also import constitutional law principles, and ultimately they determine that the Limitation Act was not intended to apply to causes of action created by federal statutes such as the Patent Act, which are subject to a discrete limitation period. They also noted that it would be undesirable to have different limitation periods apply depending on where you commence your action. And so, again, just as a takeaway from my perspective, in Alberta, patent infringement claims are subject to the limitation period as prescribed by the Patent Act and not the 2-year limitation period provided by the Provincial Limitations Act. Now, this case was decided in the Alberta Court of Appeal, so it's not binding on other provinces or courts in other provinces. However, given the nature of the decision, the fact that they conducted, as I said, a fairly detailed analysis of the issue, if this same issue were to arise in another provincial court, certainly this case would have some persuasive value and would help guide that court in resolving that same issue. So at this point, I'll pass it back to Dan to address the next topic. Oh, Dan, you're on mute.
Thanks, Matt. A couple of other quick topics for me, one being passing off. And passing off, if we go to the next slide, is a common law tort. And it's basically infringement of an unregistered trademark. So if you don't have a registration, there still exists this common law tort of passing off, where you have to establish your goodwill, kind of as a substitute for having a registration, deception, actual or potential harm. So that's been a common law tort for a long time. But what the Trademarks Act did was provide a statutory version of it. So it's in Section 7B. Essentially, it's a statutory version of the tort of passing off. But one of the issues that can come up is that the federal court does not have general common law jurisdiction. So if you are going to bring your passing off claim in the federal court, you are limited only to Section 7B of the Trademarks Act. You cannot assert a common law tort, including the common law tort of passing off. Can we go to the next slide? And in addition to the federal court not having jurisdiction over common law torts, Parliament can't simply give it jurisdiction over common law torts. If there's going to be federal legislation, it has to be within a federal head of power under the Constitution. And so one of the issues that the court has addressed in deciding on the constitutional validity of Section 7B is whether it actually falls within the federal head of power that would cover trademarks. And the courts have said yes, this is within federal powers over trademarks because it relates to unregistered trademarks. However, only to the extent that you are actually applying Section 7B in the context of a valid trademark under the Act. So it can be unregistered, but it would still have to meet the definition of trademark in the Act. And what comes with that is, if we go to the next slide, a requirement that you have to establish use in accordance with Section 4 of the Act. And one of the issues there is that use has a specific definition. It doesn't necessarily include advertising. So a trademark could become known, for example, through advertising, spillover advertising, perhaps from the US, but that doesn't necessarily mean that that trademark has been used, because you also need to perform the services in order to use the trademark in accordance with the definition under the Act. And so the result of this is that you have this threshold requirement for Section 7B claims to establish a valid trademark under the Act. That's required in order for the federal court to have jurisdiction. However, that may not entirely overlap with what you would have to establish under the common law tort. And if we go to the next slide, this is an older quote that really makes the point. If you bring your passing off action in a provincial court, you don't necessarily have to meet the requirement to have a valid trademark under the Act. For example, maybe you're dealing with something like the spillover advertising scenario that I was referring to. You can't necessarily meet the definition of use in the Act, but perhaps still could make out a passing off claim. So I thought this decision from the federal court in the 24K case really was a good reminder that litigants need to think about the threshold requirement when deciding where they're going to bring their proceeding, because there may be cases where you actually could make out a passing off case, but maybe not meet that threshold requirement. Okay, next. And the last topic that I'll be covering, this is not included in our article, but it's kind of a little bonus. It's a decision that came out near the end of the year in Toronto Star newspapers versus OpenAI. And if we go to the next page, it's kind of the first decision to come out of the growing amount of AI-related litigation in Canada. What this case was about is that a group of major Canadian newspapers, the Toronto Star and others, there's a whole list of plaintiffs. They sued OpenAI, the maker of ChatGPT, and in broad terms, the claim alleges that OpenAI used the newspaper's copyrighted content without authorization for training its AI systems. And that conduct gave rise to copyright infringement. There was also some other torts that were alleged. So essentially scraping data from the internet, including those newspapers' articles, and copying and using those articles in the context of training. Now, OpenAI brought a motion challenging whether the Ontario Superior Court had jurisdiction to hear the case. Essentially, OpenAI was saying, look, we operate in the US. All the copying and training that we did was in the US. The only thing that may have been in Canada was the newspaper's web servers receiving requests to send web pages and saying, sure, here you go. Essentially what happens when you surf the web, whether by bot or as a person. And they say, well, that's not infringement because the newspaper sent it. But once that happened, any copying and training took place in the US. Ontario courts have no jurisdiction. And so the issues that were specifically addressed were subject matter jurisdiction, personal jurisdiction, and forum nonconvenience, which is essentially even if there is jurisdiction, is Ontario the right place to have the dispute? If we go to the next slide, okay, so subject matter jurisdiction was dealt with really pretty quickly. OpenAI's argument was, look, the copying was outside Canada, so the copyright can't apply. There's no subject matter jurisdiction. But the court said, well, that's not really what subject matter jurisdiction is all about. It's about whether the court can hear the type of claim that's being brought. Like, can the Ontario Superior Court hear a claim for copyright infringement under the Copyright Act? And the court said, the answer is yes. Therefore, we have subject matter jurisdiction. The idea that the copying took place elsewhere was really something to be considered in personal jurisdiction. And then when we come to personal jurisdiction, the way it works is that there's these presumptive connecting factors that are listed on the screen. If you establish any of those, then the defendant can still make the case that, well, yeah, there's this connecting factor, but it's really, really weak. It doesn't create a real and substantial connection to the province. Here, the court went through the factors. They found, yes, OpenAI does carry on business in the province. They have customers, advertising, contractual relationships, scraping activities in Ontario. So they meet that one. They also consider that the tort was committed in the province. The court wasn't really willing to make a finding on whether the scraping or the kind of accessing of the content was or was not an infringement, but as long as there's a reasonable argument, the claim can go ahead. So the court found that that was met, and they also found that there potentially was also a contract connected with the dispute, because arguably OpenAI's web crawler agreed to the terms of use on the websites. So that was also considered a connecting factor. And the court determined that it has jurisdiction. The court then briefly considered whether Ontario might not be the correct form. OpenAI said that the US was the appropriate form, but ultimately, when the allegations relate to breach of the Canadian Copyright Act, I think it's a tough sell that it should be brought in the US, and that's ultimately how the court ruled on that question, along with considering some other factors, but ultimately the court decided Ontario was the right place. So it looks like, subject to an appeal, which I believe is pending, this decision means that this case is going to go ahead to the more substantive parts of it. And I'll turn it over to Matt. I think he has another couple of quick topics, and then we'll answer some questions.
Yeah, I'll try to be quick on these last two. They're both relate to copyright cases. The first one I wanted to discuss is a copyright action for 2025 that was dismissed for lack of standing. And this case follows a few recent decisions of the federal court where the plaintiff's claim for copyright infringement has failed for not meeting kind of the functional requirements of ownership or establishing ownership. So this case is McQuaig v. Enbridge Gas. And as I mentioned, it's a copyright infringement claim, which was originally brought by Mr. McQuaig, an individual, and also in the name of his company, 108, against Enbridge. And the asserted copyright was in respect of computer software. So early on in the proceeding, 108 discontinued its claim, and Mr. McQuaig continued as the sole plaintiff, and I understand that he represented himself. And this decision arises from a motion by Enbridge to strike the claim on the basis that Mr. McQuaig lacks standing. So standing is it's a fundamental requirement for any claim. In the copyright context, standing flows from ownership of the copyright or having been assigned those rights by the owner. And so in this case, on the motion to strike, it was the job of the court to assess whether Mr. McQuaig had any ownership rights or was assigned ownership rights in the asserted copyright. And on motions to strike, you have to assume that the facts as pleaded are true. So that's what the court did here. And I've just briefly summarized on this slide the relevant facts that the court considered to determine whether Mr. McQuaig had any ownership rights, whether he had any standing to bring this copyright infringement claim. So in 2013 to 2014, Mr. McQuaig created this software. He developed it on his own, and he started licensing it to Union Gas, which was later acquired by Enbridge. So he was the original author, the original creator of the software. In early 2019, however, he assigned all copyright to his company, 108. In 2019 to 2021, further modifications or enhancements were made to the software pursuant to a service contract where 108 was identified as the supplier. So the service contract was between 108 and Enbridge. And so in those circumstances, once again, any copyright that existed in the enhancements to the computer software would have been owned by 108 as the supplier and not Mr. McQuaig. There was another version of the software, so further enhancements, modifications were made in 2021 to 2023. But at that time, Mr. McQuaig was an employee of Enbridge, and he was making those modifications during his employment by Enbridge. And in those circumstances, under the Copyright Act, that copyright would be owned by the employer, and once again, not Mr. McQuaig. And so ultimately, the court found that Mr. McQuaig did not own any copyright in any version at any time, except, I guess, prior to 2019 in the software, and therefore lacked standing to sue. And for me, a couple takeaways from this case. Number one is the fundamental nature of standing, and to ensure that a party bringing a copyright infringement claim, again, should double check that they have clear and a clean chain of title that they can actually prove and establish for the court. And number two, it serves as a reminder that on-the-job creations by an employee, the copyright in those creations belongs to the employer, absent an agreement to the contrary. Okay, final topic. I'll try to get through it very quickly so we have time for questions. So this is a Court of Appeal decision which acknowledges the novel defense of misuse of copyright. So this misuse of copyright defense, I'll explain it in a little bit, but it has never been adjudicated in Canada, and Bell Canada raised it in their statement of defense as a defense to claims brought by Millennium Funding. So in this case, the plaintiffs are a group of film studios, Millennium Funding, and they are suing Bell over alleged failures to forward copyright notices under the notice and notice regime. So the notice and notice regime is where a copyright holder can send notices to an internet service provider like Bell, identifying alleged instances of copyright infringement associated with IP addresses. And then Bell has to take those notices and forward them to the subscribers associated with the IP addresses. And they're required to do so by the Copyright Act. So in this case, Millennium alleges that Bell failed to deliver half of the 81,000 notices that they sent over a 28-month period. And they're claiming statutory damages for each failure at the maximum end, totaling about $400 million. And so in its defense, Bell raises many defenses, including this novel defense of misuse of copyright. And as I said, I say it's novel because it's never been adjudicated in a Canadian court. It has been relied upon in the US, and under US law, the misuse arises when a copyright holder attempts to extend his copyright beyond the scope of his exclusive rights in an anti-competitive manner, or that is contrary to public policy embodied in the copyright or in copyright law. So, for example, if I own copyright in computer software and I'm licensing it to someone, and as part of that licensing agreement, I say, okay, you can use my computer software, you pay me a licensing fee, but also you have to agree never to develop any competing software at any point in the future. So in that situation, arguably, I'm extending my copyright beyond the scope of the exclusive rights granted to me in a manner that is stifling competition or that is anti-competitive. So in this case, Bell is alleging that Millennium is using their enforcement strategy not to protect their copyright, but instead to intimidate potential infringers and extract settlements from them, and also to claim exorbitant amounts from ISPs alleged to not be delivering these notices. And so this decision was in the context of a motion to strike, and Millennium was seeking to strike this defense as well as other defenses. But ultimately, the Court of Appeal held that no, this is a potentially viable defense that Bell can argue at trial, and they permitted them to amend their statement of defense to plead sufficient material facts in support of that defense. So my takeaway from this case is that copyright misuse or misuse of copyright is a potentially viable defense. And as I said, this was in the context of a motion to strike. So it hasn't been adjudicated by a court, but this case will be worth monitoring going forward, especially if it makes it to trial. So that was my last slide. We now have time for some questions, and I see we have at least one question in the Q&A box. And that question is, and I guess either of us can answer it. It's not directed to anyone in particular. But the question is, do you recommend any tools for tracking Canadian patent litigation like RPX in the US?
The one that I use is ippractice.ca to track Canadian patent litigation. I don't know if it's similar to RPX, but that's what a lot of people subscribe to, that allows some like tracking of cases or just generally.
Yeah, I use the same tool, IPP Practice. And you could subscribe to certain cases that you're particularly interested in. So it will send you email updates automatically anytime something happens in that case. But also it will just let you know by email when a new case has been filed, when a decision has been issued, that kind of information. So yeah, I'm not sure if it's similar to RPX, but it is a helpful tool for tracking litigation in Canada.
All right. If anyone has questions, put them in now. Otherwise, I think we can wrap up. So just as a reminder to everyone, when the webinar ends, a survey link will pop up on your screen. We ask that you take a moment to share your feedback on the webinar. Looking ahead, we have a patents year in review webinar tomorrow. We have a trademarks year in review webinar on Thursday. So sign up for those. And this webinar may be eligible for continuing professional development credits. LSO, that's Ontario. This program has 1 hour of substantive content. LSBC, this program contains 1 hour of accredited content. Barreau de Quebec, this program is eligible up to 1 hour. So thank you again, everyone, for joining us today. We certainly hope to see you at those sessions and our future litigation sessions as well.